Everyone, I'm here today with Lawrence Cohen from Gordon and Reese, a securities lawyer, and we're going to talk about everybody's favorite subject, which is securities fraud, market manipulation, and some recent cases and kind of some historical cases. So, Larry, thanks for being here.
My pleasure. And
Uh,
it's the holiday season, so happy holidays to you and all.
and to you too. Um, just as a quick bio, would you kind of give everyone a quick bio on you, just so they understand kind of what
Sure.
your background is?
Thanks, John. I have about 4 decades of experience and started on Wall Street, working at some major institutional firms, Lehman Management, and then went into the private law firm side uh, back in the 80s, multinational law firms in New York. And I've represented broker dealers, investment advisors, hedge funds, other private fund groups. Worked on IPOs, which just came in yesterday. So I've got sort of a broad background in securities regulation. Now, I'm not a litigator, but I certainly worked with my litigation partners, second sharing different cases, and I've done compliance work as well. I actually registered the Blackstone Group when it started with
Really?
4 employees back in '83,
Wow.
and watched it. Yeah, it was a little tight group, but obviously expanded. And
That's like being the witness to the moon landing, but for cap markets.
that's a good analogy. Yeah. And I still have a very nice letter from Steve Schwartzman that I keep in my library here.
That's
But
amazing.
so that's, I'm a utility infielder as far as securities law is concerned.
That's awesome. Great. So kind of the impetus for this conversation initially was this recent SEC case against Atlas Trading and kind of this little Twitter group of I guess you pump and dumpers at this point. Like it's an interesting thing, like to see how like so many young people who came up in the social media world started to use social as a channel to talk trading. And as they gain followers, some are more ethical than others.
Yeah.
So like,
Well,
would you mind like kind of giving everybody kind of an overview of what the charges are and what that case looks like and what the issues that are there specifically?
sure. First, to preface that, it's a kind of a classic pump and dump situation, and that refers to purchase of securities with the intent to drive up the price and then sell them. And I think a lot of your participants are familiar with the whole legacy of that area. And I'm old enough, as you can see by my gray hair, to remember pump and dump schemes going on by telephone and fax and letters, etc. And now, as you mentioned, it's evolved into a very immediate online ability to conduct fraudulent activities of this nature. And this case is a very interesting situation because it involves such egregious behavior. You rarely see S.E.C. complaints that go through a line by line blasting of some activities that the defendants were engaged in. In this case, there's just a litany of overreaching and illegal statements and lies, not just misstatements. I mean, very straightforward exaggerations that are material and really put these I'll say fraudsters in hot water. Now again, these are still allegations, and the actual I have to put my own disclaimer out there that I wasn't involved in the transaction in the representation, but any of my comments are just simply my own opinion.
Right now, but like
Now,
the SEC did say so, like it was like $100 million, $100 million
Yeah,
fraud screams what they're accusing them of, and they said that
right.
there's 7 defendants that promoted themselves as successful traders and had hundreds of thousands of followers on Twitter and Discord chat rooms.
Yeah,
And they were pumping and dumping. Is what the accusation is, right?
exactly. And the problem with these sites like Discord and Twitter, of course, they're ubiquitous. They can go out into the ether and just make all kinds of claims. And there is, in this case, there was a long-standing pattern of this kind of abuse. And one thing it does underscore, again, for your listeners, is that, you know, you have to have material misrepresentations in order to cross the line and be deemed to commit a fraud. And materiality, you know, is a spectrum of activities depending on, you know, would the typical investor make an investment decision based on that information? Is it material, meaning are the stocks actually being manipulated to the degree that it would move the price of the stock? There's a lot of factors that you have to explore before you can actually charge someone with a violation of the fraud statutes.
So,
So for a lot of situations, in fact, I talked to a client the other day, a small group that were very nervous because they said, yeah, we mentioned things on Twitter and we're concerned, are we going to get, you know, a knock on the door from the SEC? And, you know, their activities were very limited, very small. They didn't make much money, if at all. So, you know, people have to understand that the SEC is not going to go after everybody out there for any little
well,
immaterial misstatement.
I guess I want to parse this into, like, because to me this is a great, like, this case is a great frame for several distinct conversations, right?
Yeah.
And let me just lay what those are in my head out, and then we can run through them, and you can tell me if I'm thinking about this right. On the one hand, you have the hey, I'm a trader and I'm posting trades on Twitter, and I own the things that I'm actually making these trades, and other people who are following me might make those trades after me because I'm posting them. And so there's behavior around like that piece. Then there's the behavior around, hey, I'm misrepresenting the fact that I own these things, or I'm misrepresenting something about the stock that's not actually true to those followers. And then there's the, hey, I have a chat room, and I post things on social. Maybe we have policies about it, maybe we don't, in terms of what my traders in the chat room, like employees or gurus, can own and can't own. What are the boundaries around, like, hey, we own these stocks and we're talking about them we're talking about the trades in real time to our people. And then there's the like, and this is a professional investor question too, like, I mean, to the point of like people who are talking their book. Like, I always go back to that classic moment in Twitter history when Carl Icahn moved the Apple stock, or by $17 billion, and with a couple of tweets. And, obviously he had a very strong interest in that. And so he was able to move that quite a bit. And I know there were some SEC issues around that. And so for me, like, those are the kind of the buckets of conversation that, like, when I saw this, like, I have questions in all of these areas about kind of what this means for somebody with a trading room, someone who's an individual trader, someone who's got staff, like. And so maybe we can start with that first, like, kind of look at it.
That's a very good description of the different buckets here, because what the SEC would and any regulator has to do is prove intent to actually take advantage of a misrepresentation or other fraudulent activities. So the problem is there are many entities out there like Motley Fool and other advisors that talk about the way the markets are going to move and particular stock. Analysts, of course, on Wall Street do this as a living. The problem is, if you do that with this kind of prior intent to raise a stock price and then sell, that's where it triggers an illegal activity. So in terms of what these defendants did, they had undertaken the kind of promotional descriptions of all these securities, knowing that they were going to jack up the price and then sell. And that's the pattern that the S.E.C. looks at. And they can easily show that through records that they can subpoena from the trading of those securities, and it's all over their Discord account, etc.
And they had a whole private channel talking specifically about how they were doing this too. So
yes.
like, because I was going to ask about that issue of intent, like these guys not only were unethical, but they seem like particularly dumb in that sense, which is great because that's how but that issue of intent would seem difficult, like a difficult edge to walk on in terms of like, hey, I recommended this trade, or I told everyone that I was buying this. It went up. Now I'm selling it. After that, at what point, did my intent was always to make a profit on this trade, whether that happens or not. But the question of intent to leverage my audience to, how do you separate out the intent to publish versus the intent to manipulate the audience?
That's difficult, but if you see a pattern of this continual promotional type attitude, saying I love this stock, I'm going to buy 10,000 shares because I know it's a home run, and doing that knowing that there's small volume, the price is going to really be leveraged substantially, and then knowing you're going to sell it and demonstrating that through your trading patterns, which again the S.E.C. and other regulators can get from the trading accounts. They could subpoena your records. That's where you cross the line. If you and I were just in a Twitter exchange and I said, I think this XYZ company is a really great purchase, I'm going to make a buy today of 1,000 shares. Again, if it happens to go up in price and then a week later I sell it, that's just between you and I. But this, again, it's a matter of degree. So you've got a team of people that are sort of all conducting the same activities. And you look back and see that this was a quick flip. They bought and sold. That's the way the S.E.C. would look at this and try to pin this fraudulent activity on them. There's always, again, before the internet, I'd always get questions from people saying, yeah, I'm going to a cocktail party and my brother-in-law said I should buy John Deere, and that's I'm not talking about insider trading particularly, but then if I found out that he bought that, it went up in price, and then he sold it the next week, the S.E.C. is not going to go after somebody in that context.
Right.
This was a business these guys built, and they basically had that intent, and it was easily demonstrated by their, as you said, stupid comments. They were online bragging about having the ability to pump up the stock and sell it. So again, it's a common sense, fact-based determination. There's no black letter law that says if you do these things within this time frame, it's going to trigger a 10b5 anti-fraud action.
Right.
But that's the way all litigation is. I guess it's a fact-based determination. And these guys really push the envelope.
It's really interesting to me, just having been in the internet marketing world for so long, because I'm reading this case and it gives me these, because it says things like, so one of the guys hosted a podcast where he promoted the other guys as expert traders. So they're all kind of not just trading the same things and pumping up the same things to all their followers, but they're featuring each other as kind of like the experts. And I remember, like, and this is not securities, but like we remember this there was like this period in time when the internet marketing gurus of the world, there was like this little group of them, and they all just promoted each other, and they all said the other ones were experts, and there's like kind of like the only reason you knew they were experts is because everyone else said they were experts, and all of their products sold really well because all of the people in the group would be their affiliates that promoted it, and so it's kind of like this giant circle jerk of internet
Mhm.
marketing. And it doesn't mean that some of them weren't like great, but this reminds me very much of that, like kind of like I think they even had a name for themselves as a cabal or something. And like these guys, I'm sure had some kind of douchey name for themselves as a group that is doing the same thing, but now to like, within like capital markets where there's a lot more regulations.
Well, that's a great another analogy of self-promoting colleagues in an industry. That's fine, but the problem is, was there a detrimental impact to investors based on those activities?
Mhm.
And again, hindsight's always perfect in regulators' eyes. So looking back, if those gentlemen that you were speaking of talked about, their great abilities, but the intent was to get their clients to be involved in some money-making scheme that the promoters benefited from. That's the problem, and that's
Right.
always again a looking back situation. So the bottom line is common sense. If you think something is going to raise the attention of regulators, it's best not to pursue that.
Right. And but there are, there's plenty of people who have like, strong followings and they just post their trades and they're not necessarily, like I said, so they're not showing an intent to manipulate the market. But if they're day traders, they're still getting out fast. And swing traders, they're still going to be going in and out fast. And I think that's where, like, if I was going to play devil's advocate, like, I would say, like, it would seem that there are like activities like that. And if you're posting on social that there's like honest traders who could then, because they're doing fast trades and they have a strong following, then like the question of the intent piece,
Mhm.
like you could probably make a case for it even if it's not there. I mean,
Right.
I would
And
imagine.
that's again, if it the facts and the pattern indicates that there were um, very again favorable trades for the person making the comments, and he was able to benefit from that in let's just say not an ordinary
Mhm.
situation where if I said to you as part of my audience, I really think that we should buy XYZ. And within a couple of days of the stock jumping up in price, I sold a large amount of it. Then there's a good argument the S.E.C would look at that as being a manipulation of the
Right.
market. Now, if I only sold a small percentage because I need to pay tuition for my kids, not a problem.
Mhm.
Probably, not an issue.
Right.
Uh,
And then
yeah,
the level of liquidity then, to your point earlier,
yeah,
probably makes a big difference in making that determination.
yeah. Both the trading volume that's impacted as well as the stock price. If it's a penny stock that goes up $3 or $4, that's substantial. But if it's only 200 shares out of 100,000, nobody's going to really see a problem with that.
Right. Right. Yeah. And so then, because we see this just in the publishing world, like, and this is why the larger publishers all have very kind of like strict internal rules about what their employees are allowed to own, when they're allowed to sell or buy based on recommendations. Like it's
Yeah.
usually like I think 24 to even 72 hours after something is published before you can make a trade on that security. So they have that in place because we know that like because they have these huge audiences that when they feature things that might be a smaller cap thing or something that is going to have an impact or it could potentially have an impact. And
Mhm.
so like they're like the larger groups are really good about I think um keeping that in check.
Right.
um and smaller
That bleeds
ones.
over into insider trading regulations as well. I mean, you
Mhm.
don't have to be an executive at a company. You could be a tippee
Right.
and get into trouble because you're violating insider trading requirements. So these two areas, both individual stock manipulation and insider trading, go hand in hand,
Hmm.
especially for a larger company, as you say. And there's got to be compliance procedures in place, and somebody has to have a watch list and make sure that this employee is not going against what the recommendations are.
Hmm.
Um, so it's a very fluid area, but ultimately fact based. And
Is that what you, so like maybe like if we could give people kind of a quick like bullet list of the things that like you should do if you're going to have a compliance process in place, like what are what's kind of framework of that for like internal for employees, like you just said it, there's a watch list. um how, I mean, how are you verifying employees?
it's always an issue with a lot of companies. If you're a uh, registered firm, a broker dealer, a hedge fund, or a advisor, you are required to have conflict of interest and insider trading rules in place, internal rules, and you would monitor those activities. There's always pushback. I've given presentations for companies on the insider trading requirements, and it's amazing. At the end of the presentation, employees will always pepper me with questions like, "Why can't I just do this?" Or if I hear as I said before, my brother-in-law tells me I can buy this, or can I pass along this information to my best friend? What are the guardrails?
Hmm.
Where do I cross the line? And it really is a matter of what the facts are. So in terms of those kinds of things to look for, if you're a larger group, you should absolutely have um, somebody monitoring communications. I mean, most registered broker dealer, for example, has to retain its emails and prohibit employees from using personal um, information, personal social media
Hmm.
to refer to any business-related uh, situations. So that's one expensive proposition, because a smaller group isn't going to want to hire a consultant to capture all of their emails and monitor them. But
Right.
the larger company, that helps. You should also consistently train your employees, have a code of ethics, and have compliance review sessions. It's mandatory on an annual basis for registered broker dealers,
Hmm.
but it's best practices for other companies to do the same.
Yeah.
And just have an example: in-house counsel or an outside lawyer come in for 2 hours and sort of do what we're doing, raise
Hmm.
the attention of the staff and employees and officers, and just let them know that these rules are out there. And as you can show the cases that have triggered all kinds of fines and sanctions, like we're discussing here, to
Hmm.
kind of raise their consciousness about
Right.
what the limitations are. Um, so in terms of a hit list of various issues, there's, as we all know now, just looking at this Atlas decision, you shouldn't be out there on the internet, first of all, saying anything that's false, lying about your investment expertise and background, suggesting purchases of securities that it appears and will be shown that you had the intention to sell after the price goes up,
Hmm.
and just basically being discreet about the level of positive information you present. I mean, it's okay to say this is a great company, but if you say it's a great company and I'm going to buy 10,000 shares and so should you, without saying, oh yeah, by the way, I'm intending to sell it, nobody's going to do that in the real
Right.
world. Say I'm
Right.
going to sell it after it goes up to a certain level. But looking back, as the S.E.C did here, that's what the trading record showed.
Hmm.
So be very cautious about what the timing is for these kinds of transactions.
That makes sense. No wonder this might be maybe this might be a question for your colleague David Wright on the publisher's exemption. But like when I looked at this, because there's this thing called the publisher's exemption that
Yeah.
was a Supreme Court case, and it's basically like for everybody, if you're just if you're a publisher, your marketing is under First Amendment rights. But if you're and you're not an advisor, so you're not under the S.E.C. from a marketing perspective, basically, right?
Yeah.
One of the little like finer points of that, my understanding was from another conversation I had with one of the internal counsels over at Agora a couple of years back, was that there's the issue of being a periodical, right? Like, and so a one-off report, even if it's a publisher, right, it's not a periodical, so you're not really covered. And so I think about like the way that like traders on social promote themselves and have courses,
Mm-hmm.
not periodicals. And so it's like a book maybe, but then they're also posting live trades, and maybe it's just untested law. Are they protected by the publisher's exemption if it's not a subscription, if they have educational courses, or if they are promoting themselves like with a podcast that is just like, I guess a podcast could be a periodical, but if they're promoting themselves as these amazing traders and like pushing like their trades, like there's got to be a lot of just gray area in the way some people are operating on that.
Just to back up, and that's a good point. I was going to hopefully get to this, but that publisher's exemption or exclusion is from the definition of an investment advisor. So that enables someone to engage in these kinds of promotional activities, but not be deemed to be an investment advisor,
right,
which brings a lot of other regulatory baggage with it, of course.
Mm-hmm.
And the nature of the publication, so the language in that case, which was Lowe versus S.E.C., was that it has to be a bona fide publication. It's got to be disinterested commentary on a regular schedule. So you can't just look at the market and see the market, change radically, send out a newsletter, and trust that would be considered to be a regular scheduled commentary.
Right.
It happens all the time, though, of course, but everything is again a matter of hindsight. So, for your point, if you are a publisher and you are relying on the publisher's exception for the advisor definition, again, it has to be disinterested. It has to be to a broad audience. You can't. The more important point is that it can't be based on personal situations, circumstances for the customer or client. It's got to be impersonal, so that nobody could say, yeah, you published something that was directed to Larry Cohen, because that would, not be a impersonal presentation. And then again, if people are presenting these kinds of what's the word? The analysis of particular securities in a quote publication, again, it's got to be done through a regular periodic presentation, not tied to that person and his circumstances, or tied to a specific market event.
Mm-hmm.
And there are cases that go back and forth over that's been since 1985 that address this situation in different scenarios. So I don't know if that muddied the waters.
No, that's good. But it's kind of like that. Like, so you're, let's say you're a Twitter trader and you've got, you get a DM from somebody that says, hey, I'm retiring in 3 years and I'm trying to do this. And what do you think I should do? And you're like, buy this. You just crossed the line into investment advisor territory that you're not licensed.
Yeah.
Right. Okay. But I actually let's run through some of these like cases in history just to kind of give people some kind of stories that because it helps you to understand like the the different ways that the market manipulation schemes have happened and kind of
Sure.
and so I don't know if you want to run through a couple to start with. Like what was the you had a list here like the
Yeah.
SEC versus
Okay. Yeah,
yeah.
I'm happy to jump in. I'll refer to my notes, but there are, first of all, again, market manipulation has gone on since the passage of the securities laws in 33 and 34. So the interesting development has been with technology and the use of the internet and other faster media to really sort of make the circumstances more robust from a ability to commit fraud. The back in '95, first of all, this doesn't only apply to trades directly on the market for individuals. Mutual fund executives have been in trouble for trying to pump up the stocks that the funds have held. There was one case, Fidelity, an executive did that in 1995 with respect to Micron securities. And it basically created a selling opportunity by jumping the price of Micron. And it was, again, a purchase done through a mutual fund.
Mm-hmm.
Now, other situations usually involve direct investors. An early case, and I have if anyone wants to contact me, I can get them the actual sites and the links to these cases. But S.E.C. versus Huffo was in '98, and that was brought against individuals who distributed false and misleading information, as we said, through the internet about stocks that they owned as part of a scheme. It was a pump and dump, inflate the share price and encouraging others to buy them. And the defendant was cited for touting publicly traded securities in articles he wrote on the Whisper newsletter in return for undisclosed compensation. And that triggers another issue. This is under 17B of the Securities Act, where if you're getting paid in any way, shape, or form, it doesn't have to be cash, it could be other benefits that you're receiving that are remuneration from the issuer to promote their stock, and you don't disclose that, it has to be disclosed and has to be clearly disclosed. That's a violation of Securities Act Section 17B.
Right. And so that's for anybody who takes advertising from anything that's security, that means you're disclosing that you were paid, how much you were paid, and like
your website and your literature should all have a little disclosure at the bottom saying, we're talking about XYZ company, and in return, we are receiving either, you have to be very clear about the compensation. You don't have to get it down to the penny, but you have to say we're getting paid cash, or we're getting our expenses are being paid for visiting the company or analyzing.
And that's what Kim Kardashian got busted for on that crypto thing, right?
Yes, exactly. Good point.
Yeah. So can we take let's take a quick detour, actually.
Sure.
Sorry, just because I wanted to bring this up too.
Go ahead. Before we jump there, just so I don't forget, we always ask clients to put in appropriate disclosure like that. But the S.E.C. has said that in a lot of cases, a disclaimer, if it is proved to be false, doesn't rescue you. It's not the solution that can eliminate any liability.
Well, what does that mean? What specifically is proved to be false? The like if you put the wrong number in, or
no, if you have a disclaimer that is actually proved. There was a case, Douglas Colt. He created this company called fasttraders.com,
Hmm.
It was back in 2000. He was uh, sued by the SEC for posting disclaimers on his website, but the SEC concluded that they were materially misleading as to the real trading intent of the various officers of Fast Trader. So it's kind of a catch-22. You put the
Hmm.
disclaimer in, and if the SEC feels that that's misleading because your real intent was to sell after the stock rose, they catch you.
Ah, okay. So you could take, so like
So,
you get compensated to, or you put a disclaimer in that you own these stocks or whatever,
right.
whatever the disclaimer you think is covering you, but your intent was still to just pump it up and sell to people and
Yes.
screw them.
So
It
it's a
doesn't matter what.
gotcha.
Yeah.
Right.
So then you're basically like in
Right.
trouble, more trouble.
So I'm just saying that not, to suggest that disclaimers are a panacea. They're not.
Right. Yeah.
Just by
Disclaimer.
putting it in, you have to abide by it and not show that you've been um, acting in opposition to the terms of that disclaimer.
I think that's good. That's a good point because I think a lot of times I've seen this in general, not just with the people that I know who've done some stuff in the securities area, but like there's this like hope that a disclaimer covers your butt on everything, and it's like a
Correct.
disclaimer doesn't protect you from illegal behavior.
Yes, exactly. Perfectly put. Yeah.
Um, and so it's kind of like you still have to know where all the boundaries are and make sure that you're like covering your butt. But it is confusing because it's like a lot of times I found that there's a lot of people who, especially in the digital environment, kind of they didn't come from the securities world. They came from the digital marketing and publishing environment, and it just
Mhm.
kind of their career evolved in a direction. And so it kind of you don't know what you don't know, and that's not a protection under the law, but like I have sympathy for some people that I've seen who are like, oh, like I said it was an ad. I said that I got paid, but you didn't disclose the fact that like you got paid a specific amount. And so like you didn't know, like now you know, that's not going to cover you if the SEC looks at it. But like I have sympathy for that ignorance.
Yeah. Mhm.
um up to
Well,
a
you
point.
mentioned that
Up to a point.
that also is an issue that you mentioned. My colleague Damon Wright, who focuses on Federal Trade Commission (FTC) issues, and the same thing applies there in terms of marketing statements that are patently false or misleading. And the FTC is very, very aggressive about
Hmm.
pursuing that kind of language. So you've got a kind of a two-front war. You have to be
Hmm.
careful about the FTC as well as the SEC in any kind of disclaimers and disclosure that you're providing on your publishing and websites.
Right. Yeah. And so then the pivot that I wanted to take real quick was I don't feel like you can talk about securities fraud without talking about crypto, especially right now.
Yeah.
But really the whole history of crypto, um, in the sense that like the ICO boom was, you know, you had this whole securities market that wasn't labeled as securities, and the internet marketing world and everybody else got together and it was like the greatest. I feel like the ICO boom was like the greatest pump and dumps schemes of all time in a sense
Mhm.
until FTX actually happened, and then you have this whole other level of fraud that is just like holy crap. um, but the environment on crypto has obviously changed quite a bit,
Yeah.
and it's in the process of changing even more, I guess. How would you kind of describe where we are in this with the SEC in crypto right now?
Well, as everyone is following these events worldwide, crypto was always touted as the next best thing. You don't need to be dealing with banks and government institutions. It's a one-to-one transaction and it'll make life easy. And the blockchain works great. However, so many problems arose in terms of fraudulent activity that, and the pricing was just incredibly volatile, that regulators looked at it carefully. And over the last few years, both through the Trump and Biden administration, the SEC is getting closer and closer to considering cryptocurrencies to be securities. Now, ICOs, securities are determined not just by their particular features, but how they're offered and sold.
Mm-hmm.
And if you have, that's where the concept of an investment contract comes into play. And that says that if you're buying any kind of an instrument investment that's managed by others and that is being provided to you based on their investment expertise, 9 times out of 10, that will be considered to be a security
Mm-hmm.
that has to be registered, or an exception has to be found. So cryptocurrency was under the radar for the first several years of development, but then the S.E.C. looked at these ICO arrangements and is very close, if not on the cusp of determining that they should be securities and they should be registered. And that's going to be a major impact to the cryptocurrency universe, which basically it was designed to not be regulated. Not only the S.E.C., the CFTC is looking carefully at this because cryptocurrency can technically be considered a commodity in terms of a swap or other arrangement that may not necessarily be a security, but it could be a commodity that needs to be registered. If not the commodity registered, the person that's making advisory decisions may have to register as a commodity trading advisor, or if you're introducing a client to a commodity exchange or what's called an FCM, a futures commission merchant, which is like a broker dealer, you may be required to register as an introducing broker with the CFTC. And there was a no action letter issued by the CFTC that said that about a company that was doing just that. There's still a gray area there. And in fact, I've been reaching out to attorneys at the CFTC to clarify that arrangement. Because if you're a publisher or a training company, the question is, if you tell your clients to go onto this trading program and they're engaged in any kind of a commodities trading like foreign exchange, does that mean that you're introducing them and have to be licensed as an introducing broker under the Commodity Exchange Act? That's not clear at this point. I'm still waiting to hear feedback from the CFTC as to whether that would trigger anything.
That's so just to really hit this home, like the first thing, like I have a friend who filed, I think, the first petition with the S.E.C. that the cryptocurrencies pass the Howey test. Like they kind of were like, this is and the Howey test is there's a couple elements there, and I was just going to read this one thing as I just pulled it up on the S.E.C. website because I thought it was really good. Like the concept of an investment contract. It says, under the Howey test, an investment contract exists when there is the investment of money in a common enterprise with a reasonable expectation of profits to be derived from the efforts of others. And that's it's a common enterprise. That means there's more than one person involved. And you're basically investing in something because you think it's going to go up and make a profit, which is like it's almost like anybody who reads the Howey test and then has been around crypto for any period of time, you're just like, okay, well, it's really just been a matter of time for the S.E.C. to get to the point where it's like this is security, and the market has operated since its inception essentially as this, like, we've watched what happens in an unregulated securities market. Basically, we've had this like weird experience of living through a period of time when you have things that are functionally whether they're labeled that yet or not, they're functionally been securities, and like we've seen this huge like explosion of both innovation and this explosion of fraud, and all over the place. Like it's been a wild ride to sit and be a part of and watch and see, and like it's been fascinating just from that, like if you're a student of markets, to watch how this is developed. And then now we have like, the great reigning king of crypto fraud with SBF, um, sitting there with FTX, and like it's breathtaking, the level
level.
of fraud that happened there.
What's more breathtaking is the lack of due diligence done by institutional investors in FTX.
Mm-hmm.
And, we've all lived through the Madoff, debacle where this ultra respected, Wall Street guru who was on the NASDAQ board, was just making things up and people were lining up to give him money.
Yeah.
And the same with FTX. I mean, the guy had smoke and mirrors, and people didn't question it because of greed. Um, where we are now is, he's being indicted, and I think that your instincts are correct. The regulators have to do something at this point, and Congress will step in as well and make sure that the SEC does something. This can't go on unregulated, unfortunately. And again, the Howey test is a real kind of a kitchen sink approach to many instruments that may or may not be securities. But once, a problem arises, the SEC will look back and see what those instruments were designed to accomplish. And as you said, if it's a common enterprise and somebody's, taking your dollars to increase the value of that instrument, then it's most likely, if not definitely, deemed to be a security.
And then if it officially happens and it's like, okay, securities, then it sounds like the CFTC is standing right there behind it to say it's not just a security, it's a commodity.
Yeah.
In which case, the CFTC has a whole other layer of regulations.
Right. There is, exactly. And that's the craziness of our U.S. Investment economy, that unlike other countries, we've got the S.E.C. and the CFTC. I've said for years they should just be the same agency and monitor all of these instruments, but politically, that's probably not going to happen in my lifetime.
Yeah.
And the CFTC may call them, depending on how they're structured, a commodity, like a swap. I look at swaps as being something that the S.E.C. should probably regulate because they're so involved in financial transactions. But definitionally, they fall into the CFTC's area. So same thing with crypto. I think that depending on what type of instrument is designed, it's, if it's a Bitcoin, probably it'll be a security. If it's some other kind of exotic product, it may be viewed more as a commodity and go under the FTC's umbrella.
Yeah. Yeah, it's been interesting too, because I feel like there's this whole generation. Like I think that there's this. I think of it as a secret history of crypto, right? Like we always talk about this from the investment side, but then there's this other trend that happened here where you had this entire generation of digital entrepreneurs and marketers, and not just digital, but founders who basically they went into crypto, and the ones that didn't get that weren't fraudsters, that didn't get kind of successfully wiped out. They've matured and they've developed into essentially like sell side entrepreneurs, and they're become increasingly comfortable with the idea that they're working in a regulated market, that they're increasingly comfortable in sell side security businesses, basically. And I think that as this like switch happens, if it does happen to crypto being securities, now we're going to have this huge group of entrepreneurs out there who are comfortable enough in sell side businesses, looking at this and saying, well, I mean, I'm regulated now. What besides crypto could I be doing? And I think that there's going to be like, in the end, like kind of a little bit of a I'd say a sell side business boom in my mind. That's coming.
I think that's probably correct. And this also reminds me, very early in my career when I just left law school, I mean, only a select few people were really comfortable with options trading and understood that market. now it's ubiquitous and it's sort of a traditional, security. But at the very early stages, people didn't really understand options and know what they did. And eventually it became acceptable, a traditional type of investment approach.
Mhm.
I think that's going to happen with crypto too. Crypto is still evolving. There's people that are trying to make money on just mining crypto versus trading in it.
Mhm.
I've got a client that is that set up a crypto fund. It's a private fund that is investing in crypto, and once that is fully developed, I think they'll have a very good asset base of quote
Mhm.
accepted regulated securities, just like any other security. But I think
Yeah.
it's going to happen. I think Gary Gensler at the S.E.C. has been very vocal about, calling for the need of this area to be regulated.
And I would say, like, anecdotally, I can think of like so many different people who I know who've been dramatically damaged by it. I think of, like, not just directly but indirectly, like people who were like, oh, my lead investor got practically wiped out. um and so
Right.
there's enough rich people getting hurt
Yeah.
to all of a sudden like change like some of the views on, like, hey, maybe we don't want to have this completely unregulated.
Right.
And then yeah.
The only ones who really made out well are the celebrities that did the commercials over the last year.
Yeah,
I don't think
that's
Matt
right.
Damon and Larry David are hurting from the crypto industry's issues.
Yeah, as long as they didn't put their payment into FTX.
Right.
Yes, it's always better to be taking the money from the exchange there than it is to
Right.
put it into a crypto exchange, I guess.
Yeah.
But um
But I do monitor that area with respect to the S.E.C. And, if things happen, I'll be happy to put you into a list of our clients that are interested in seeing where this goes from a
absolutely.
regulatory standpoint. Yeah.
Yeah, no, definitely. I think that's one of the more interesting areas of development that we're kind of all waiting on, I think. um
Right.
uh but
And
um
with respect to market manipulation, again, it's a kind of an easier thing to be delving in because people feel that it's not regulated. I'm not really doing anything wrong by talking up an instrument. And I won't call it a security, but an instrument that is not regulated necessarily. So where does that fall from my standpoint?
mhm.
And if they don't, then they're not knowledgeable about it. They don't realize the S.E.C. is, going after bad actors in this
Yeah.
crypto sector as well. It's
Do you
it's not completely off the radar.
Right. Do you think that if they, and I want to say when they say it's a security officially, um, do you think, because we know they're looking, like you said, they have that they're looking backwards. Is it going to be a situation where they say not only is it a security, but it has been a security for quite a while, and they're going to go backwards and look at people's behavior and say, and look for people who might have done something egregious, and bring cases? Is that a thing that they do, or is it more like, hey,
Yeah,
okay, from this line forward, just everyone understand this is a regulated market, these are securities, and we're just going to like adapt from here forward?
yeah, I think the latter. I don't know of any other situation where the SEC is given retroactive
Okay.
imposition of registration or other requirements,
Right.
until it's clarified. And I think any court would throw out a enforcement action
Okay.
that talked about something in the past.
Yeah.
But once it happens, it happens. Now, so for example, if now Bitcoin has to file for registration as an issuer of cryptocurrency, that would apply, retroactively to people
But
that hold it based on what it is deemed to be under the current or new
but how would,
regulations.
like,
So,
who would even file Bitcoin?
yeah, I
As in,
guess
like,
you'd
who would
have to
even,
find anyone that is. It depends. As the SEC may view
all the miners basically?
mining. Right.
All the minors.
Yeah.
Okay.
Yeah.
Man, some changes coming.
That's why this hasn't been resolved up to this point. And
Yeah,
blockchain's not going away. That as a
for sure.
technology is actually very, very helpful for all kinds of industries. But the financial industry is still trying to wrestle with what that creation of a new instrument, mining a new coin, is that no different from issuing new securities.
Mhm.
And, in my view, I think it should be once they decide whether or not it is or isn't a security.
Right.
Yeah.
Yeah. Huh. Well, I guess we're gonna see.
Yeah.
We're gonna see. Um, all right. Well, the one other thing I wanted to talk to you about real quick before we wrap up is you know, that going back to the idea of introducing brokers, commissions, people who are getting involved in things like uh, I'd say private cap raises, things like that. Like, what are the boundaries between like a finder, an introducing broker? You know what I mean? Like, because you have like
Yeah.
a lot. I'm getting a lot of these kind of questions from folks just because there are like we have like the crowdfunding and Reg A space, for instance, in the publishing world is very, very active in terms of featuring companies because, and when in the Reg A space and the crowdfunding space is super active in trying to make relationships with influencers and with publishers because they need like a mass audience to make those raises work often. Um, and the way that they compensate people and middlemen in there, like I've seen a wide variety of things, and sometimes I'm like, I'm pretty sure you've crossed some lines, folks. And so what
Well,
are those kind of boundaries? What are those definitions?
uh,
Yeah.
not to be facetious, but this is a tale as old as time. The I mean, throughout my career, the question of who is a broker dealer is up front, and it's evolved. There was a famous, I mean, widely distributed no action letter dealing with Paul Anka decades ago,
Mhm.
and the S.E.C. responded to his lawyer's letter as to whether his ability to fundraise for a pasta company and get a commission would deem him to be a broker dealer. And the S.E.C. said at that time, no, he's an entertainer. Everyone knows he's an entertainer, and just because he's getting a little, percentage,
Mhm.
it's okay. He doesn't have to register. Well, that went away over the next few decades, and now the position of the S.E.C. is basically if you are being uh, paid a commission to raise capital and you're doing it as part of, again, the question is whether you're engaged in the business.
Right.
If I went to, or if I told you, I think it's a great opportunity for you to invest in this private partnership. And I'm a lawyer, but I happen to be getting some shares for bringing you in. It's not as part of a regular business. I'm doing it as a one-off. Almost certainly, I would not be considered to have to register as a broker dealer.
Mhm.
But there are a lot of people in the financial world that are more connected to a number of people, and they'll make referrals and they'll receive some kind of a commission. And the commission
Mhm.
is considered to be a salesman's stake. So if you're being paid to bring in money, you would be likely to be viewed as a broker dealer and have to register and have to take the
Mhm.
qualification exams. Now, there is an exemption under the Exchange Act if you are an employee or officer of an issuer and you're not being paid just for bringing capital in. You've got other operational responsibilities. Under 3841, you can basically avoid being registered as a broker dealer or a broker.
Right.
So, in the real world, again, it happens every day. I wish I had a dollar for every person over the last few decades that told me, yeah, I've been raising money for this company. Does that mean I had to register? And sometimes the facts were not very positive, and yeah, you basically were in violation. And the problem there is that not only is a violation on their part
Mhm.
for acting as an unregistered broker dealer, but if the issuer knew about it, they may have to give rescission to the investors, give back the money.
Wow.
That's a slap against the company that took this guy's investments. So the short answer is, yeah, if you are raising capital and you're doing it on a regular basis, it's not a one-off kind of transaction, and you're being compensated for it and not doing anything else for that company, so to
Mhm.
speak. You're not a consultant in some other capacity. You almost certainly would have to register as
Yeah.
a broker dealer.
Yeah.
And I have had, just to point out, clients that have come to me and said, look, um, I'm really, they hired me to basically help structure the company and engage in some operational activities. And on one occasion, I had an opportunity to introduce somebody to the company who invested, and they wanted to pay me something for it. You look at the whole picture, and it's not likely that guy would be considered to be a
Right.
dealer, because he has some other real duties,
Mhm.
not just raising capital. Um, and
Yeah.
again, it's unfortunately, it's a spectrum of activities that you have to look at.
Yeah. No, I think that's helpful because I've had I've had like personal experiences, and then I've had other people that I talk to who and people say all kinds of things, but
Yeah.
um
Well,
that's
you're
why I
not
like.
you're not holding yourself out as a broker. You're not, you don't have a business card that says, yeah, here's my number, call
Oh no,
me,
I don't like,
invest.
I don't go. It's interesting for me because I am I have events, and
Sure.
I have networking meetings, and they're not just with investors. They're, in fact, they're usually not with investors. They're with I bring the editorial world that we have in the publishing world, and influencers, and like broker dealers into the room, and issuer, like all kinds of people that are doing all kinds of different things. And so um but I'm approached, I would say, I don't know, every quarter at least, by somebody who is trying to compensate me under the table for some kind of introduction or something. And the irony is it's often not even for someone who's going to actually put capital in directly. It's like, but I'm always like, I'm like, these are pretty clear lines in my mind for what's okay and not okay.
Right.
And I don't have the I'm a very like I would say I'm not risk averse as a person, except for in a handful of areas. Um, and regulatory issues is an area where I have like just a huge amount of risk aversion.
Yeah.
And it seems like, and people are like, oh no, this is even like kind of some of the lines that you drew there, like, you know, um, I'm still not comfortable just because like I don't even like, it doesn't seem worth it to be in a position to be questioned about like whether this was okay or not, because
Sure.
um
I've been
these,
I've been approached as well as an attorney. There are many times when a client is a startup and say, "Hey, if you can introduce me to somebody, I'll, pay you this under the table,
right.
or can I do it?" And you can't.
Well,
Um,
that's not the thing. That's different than like,
especially,
like you said, I think like to your point before, where like you could take advisor shares if you're going to be actually doing something for the business
right,
that's not related to capital raise. Like that's a
right,
different thing. And so there's lots of ways to work with companies, but you'd have to have a real working relationship that's not
exactly.
around
Yeah.
raising capital. Yeah.
Mhm.
Um, and what is I don't even, this is more just a curiosity. Like what is a finder, and what is that
It,
role exactly?
it's not a defined term under any of the laws or
Okay.
regulations, but it's
It's
a colloquial term that just means a promoter guy that's going out there to, as we said, raise capital. He's finding investors for an issuer and getting compensated for it. And again, many years earlier, it was less of a concern that the SEC had. And, you know, if you look at the evolution of no action letters, they got harder and harder. And, you know, ultimately the SEC said, look, if you're getting a salesman's stake, you're getting a commission for putting your contact in touch with the company and they're investing money, you know, you cross the line and you have to register.
Okay, so that's I actually love clear lines from people from when like they say here's a clear line. It's the well, this in this case or this case, like where there's like all the nuances, that's where I'm like, I don't even want to try and understand. I just want to stay away from.
And one other little point is maybe not a little point, but people don't usually think of the states as regulating this area, but every state requires broker-dealer registration under certain conditions, of course. And I've had clients in the past that say, well, you know, I've been doing this for 3 years in North Carolina. And I said, did any lawyer you talk to ever suggest you have to register with the Securities Commission in North Carolina? Because you would be a broker-dealer in that state, even if you're, you know, not talking to people nationally. So
are those
people forget that.
Do those, I mean, I'm guessing the answer is no, but do those requirements line up with the federal requirements, or are they okay? So they're
fairly
not like
uniform.
Okay.
I mean, you have different fees, of course, and the forms, the registration forms are almost always the same.
Okay,
and
so
some
same
states
rules.
might have a, you know, like Connecticut has a special form they require, but it's pretty uniform.
Okay, so same rules, double the fees. Like, all right, so with local government, it's
Also, you know, the states do have exemptions that apply a de minimis number of investors in a 12-month period, et cetera. So you'd have to look at every state's requirements. They're mostly uniform, but there are always outliers. I mean, for years, well, New York's statute defines an issuer as a dealer. So an issuer securities would have to file in New York to qualify as a dealer. It's the only state that did that.
So if you're going public in that state, then that's one of the things that you're gonna.
It's one of the.
If you're raising capital as a startup.
Yeah.
Wow.
Huh. It's you know, basically checking a box and paying a fee and filing the form, but that's always been an issue. I've had clients from out of state, out of New York, that said, you know, they've been doing these activities for a few years, and guess what? You know, you never qualified in New York. So,
wow. Awesome. Well, this has been super educational, Larry. I appreciate it. I appreciate you taking the time.
Anytime. I appreciate the time, and I don't know if on your platform you have my contact information.
Yes.
But
yes, I will post that in a link. Do you use LinkedIn? I can post a link directly to your profile.
Sure.
I can, yeah. So I'll post some contact info down below for everybody to be able to reach out to you and answer, because I know that anybody who's listened this far is going to have a list of questions that they didn't get answered because there's so many different questions to ask.
Again, you know, this could be an entire business school, law school course. But I'm happy to, you know, help clarify anything I've said that may be a little muddy, and help anyone out if they reach out.
Awesome. I appreciate it, Larry.
You have a terrific holiday season.
You too.
We'll hopefully see you in the new year.
Yeah. And then have a happy new year.
Thank you.
Thanks.